which you have already answered.
Yes, Your Worship.
And then their next plea is that the procedural requirement under section 10 is not followed. To that also you have answered. So we are not going into facts that how much money is involved. Anything else you want to submit regarding that limited? Because this IA is only for staying the operation of the impugn order
Yes, Your Worship.
on only these two grounds. They are not pressing other grounds, to which you have already made your submissions.
May I allow page 14 of my reply?
Yes.
So, last paragraph, may kindly help me to read this paragraph.
No, I will not allow you to read unless I find it relevant. Because
Therefore, the request for a stay prosecutions must be denied. It is further submitted that in events of great stay against the order dated 2022, the very objective of FEO proceedings will be jeopardized, Your Worship.
okay. Anything else? In criminal appeal, we are admitting the appeal.
I don't understand my learned friend has said that the keeping in abeyance by the court, that means if your lordship passes an injunction order, staying that order, that means one can go ahead and they can do whatever they want till is not been decided. And 230 was automatically it will be reheard. Where is the question of that?
So, no, what is your submission to the law reasoning given by the trial court?
There is no reasoning as such.
One
That's the number one. I'll give two reply. To my learned friend. My learned friend says that on 2/30/2024 IA, which was filed, keeping in abeyance doesn't mean that automatically it is, he says that unless it has not been cancelled on the merit of the case, at the end, then keeping in abeyance is meaningless. That's what my learned friend is saying. So
there is an observation of the trial court also to this effect.
yes, I have seen that. That is what I am saying, that not correct.
That is not right.
That is not the correct thing, my lord. How can an observation can be given? Then an order is passed by the trial court or by a high court. Well, suppose a proceeding comes here. My lord, I am giving a very simple instance. A suit has been filed. One suit injunction has been paid for, refused. It has come to the court. Now the court said the further proceeding in the suit is stayed. Meaning that whether the learned trial will go on and say that no, we'll hear the suit and we'll evict that person. That cannot be, my lord. It's a ridiculous. How it can be? There are judgment of the Supreme Court.
Okay.
Kindly see the judgment of the Supreme Court. In one of the judgment I also, one judgment I also, I know that he will put that question. I brought the judgment also. What do you mean by events? Where the whole thing goes on, it will be. See that judgment. Paragraph 14. Kindly see 14 and 15. These judgments are not required, even then I am showing it, my lord. Your lordship asked. Judgments are not required, even then I am showing it. However, the narrow question is required to be considered in para 14.
Yes.
However, narrow question is required to be considered in this appeal is whether the winding up proceeding were pending or has come to an end when the appellant forced the winding up order by keeping it abeyance. Let it made at once clear, winding up order made by learned company judge in respect to the appellant comment neither been quashed, set aside, cancelled. Now, what is my learned friend? Revoked or nor recalled. On the contrary, after directing that winding up order shall be held in abeyance, the appellant may directed their official liquidator shall continue to act as provisional liquidator as provided by section 450 and itself is a stage in the winding up proceeding. When winding up order is kept in abeyance, it is in a state of suspended animation. Kindly see, suspended animation. The fact that the appellate bench directed that pending the implementation of the scheme as sanctioned by the High Court, winding up order will be kept in abeyance itself without anything more shows that the order was neither cancelled, nor recalled, nor revoked, nor set aside. It continued to exist but was inoperative. Any default on the part of the company in carrying out its obligation under scheme by itself without anything more would revive the winding up order. Therefore, the winding up order was effectively subsisting but inoperative for the time being, having all the potentiality of being regenerated or being brought back to life. Now, C15. Now, if the winding up order was merely held in abeyance, that is, it was not operative for the time being in force, time being, but it had not ceased to exist. The winding up proceeding are in fact pending, and the court which made up the winding order would be the court which is winding up the company. It is now well settled that a winding up order, once made, can be revoked or recalled, but till it is revoked or recalled, it continues to subsist. That is the situation in this case. If the winding up order is subsisting, the court which made the order of the court which kept in abeyance will have jurisdiction to keep necessary direction to the provision required to recourse to section 12. Oh, my lord, this is
No,
not.
it says that it is kept in suspended animation, but it exists.
Yes.
This is what the judgment says. Now, their
But
their, their reasoning of the trial court is that, as in section 2F, the requirement is only issuance of a warrant of arrest. So your submission is that if it is issued and it is kept in abeyance, then 2F will not be applicable.
that is my case. Where the warrant is pending, the warrant has been kept in abeyance. That doesn't mean, my lord, that no, unless it is cancelled or cancelled by the court, then it is pending. Warrant is kept pending. Warrant is pending. That cannot be. Then 230 of 2024, why it was recalled and reheard, to be reheard? Then there was no occasion. Then, my lord, 230 of 224 was recalled and it to be reheard. Rehearing of the case, 230 meaning that we'll hear it. Thereafter, we'll decide. Then,
Okay.
my lord, 230, if the court would have said, will not rehear, then the situation would have been different.
Prayer in 230 was for issuance of warrant only.
Yes.
That was the prayer.
Yes. And that was recalled by 531. And the court said, we'll rehear this matter. Reheard, otherwise the court would have said, no, we'll not rehear the matter. Why it was recalled? So if it is recalled, that means there was no pending warrant. So these are judgment, my lord. My lord, these judgments I shown by these judgments, my lord, otherwise it will be, with great respect, a very chaotic condition. Some orders are being passed. No, unless it is not being cancelled, we will continue. Can't be, my lord. I'm extremely sorry to say the observation that has been made by learned trial court. Can't be, my lord. So my submission that the criminal appeal be admitted, my lord. In the meantime, this order 22/1/2024, humbly I said, this order may kindly be stayed.
In criminal appeal number 1/2025, heard Mr. D. Das, learned senior counsel, assisted by Mr. S. Das, learned counsel for the appellant. Also heard Mr. K. Duvey Lotso, learned special public prosecutor, enforcement directorate. This appeal is admitted for hearing. Let the scan copy of the records of MLC case number 1/2024 be called for from the Court of Learned Special Judge PMLA, Dimapur. You want to, no. Let this case be listed when?
On 28th, let it be on 28th, it's
Twen-
Monday.
28th
of April.
is it okay? 28th of April. The interim order shall continue till next date. In this, some interim protection was given that
But
will
three, three.
continue till next date.
yes, 3.
And in 4, this I will deliver on Monday or Tuesday.
I have no problem, absolutely no problem. But that can be kept also after it's kept on the same day, 28th. Because it has to be together, then it becomes, because it is very easy to coordinate. But there is a connection with 3 and 1.
No, this I have to dispose of because I'll.
Well, it is up to the court, absolutely no problem. I have to be, yes.
In IA criminal number 4
Right.
slash 2025 heard Mr. D. Das Lanet, Senior Counsel for, assisted by Mr. S. Das Lanet, Counsel for the applicant. Also heard Mr. Kedovi Zotso Lanet, Special Public Prosecutor, appearing for the Enforcement Directorate. Let this case be listed for delivery of orders. You are otherwise under interim protection in the appeal.
Yeah, no, not to take any coercive measure.
Then let me take some time. Seventh of April.
Right.
7th of April.
Yes, implementing interim order continues.
No, that I have passed.
No, that criminal revision, one is criminal revision
No.
or in the appeal.
In appeal, it will continue.
Yes, correct.
In appeal, in the IA, you have specific prayers for stay.
Stay, correct.
That will be decided on 7th.
Right.
And in revision, you will be filing written objection. 4 weeks time was granted. So in revision also show the presence of the council. Let this case be listed on 28th of April. The ED may file written objection before the said date or on or before the said date. The interim order passed in this case shall continue till next day.
I am deeply oppressed. I am deeply oppressed.
For orders, item number 5.
This I will have to take to Gauhati. All three cases. Yes, Miss Mere, what is this?
On the last occasion, also the petitioner not appears for the petitioner. Looks like they are no more interested in the case.
What is to be done? Criminal petition.
For portion of FIR. The
Let
offense is
us
for 20.
let us give one more chance.
Gotcha.
None has appeared for the petitioner on call. Ms. S. Mere, learned public prosecutor, has appeared for the state respondent. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Item number 6.
You have engaged recently. You have been engaged recently. Heard anything? Heard Miss Easter, learned counsel for the petitioner. Also heard Miss Ayla Imchen, learned counsel for the private respondent, who prays some time for filing the wakalatnama in this case. State is also there.
Yes.
Also,
Yeah,
Miss.
next for-
Lordship, notice all the respondents are completed, Lordship.
Okay.
We filed dusty for respondent number 2 also.
Okay.
Lordship.
No, they have appeared. You
There
are
are for
two.
3. And for 2, we filed affidavit for Dusty on 6/3/25. So all the respondents, notice is complete, Your Lordship.
Miss Mary, Learned Government Council, appears for state respondents. On perusal of the Learned Council for the petitioner has submitted that the petitioner has served the notice on respondent number 2 through Dusty mode, and in that regard, an affidavit of compliance has also been filed by the petitioner. So considering the averments made in the affidavit, the notice issued to respondent number 2 is held to be duly served. Let this case be listed after 2 weeks.
Your Lordship. Your Lordship, there's an interim.
Interim shall continue. Felix.
Your Lordship.